Peace, 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 peace. This is a Marshall Enterprises presentation. Family, I'm excited. I'm excited. Got people calling me. I can't answer this call. And I'm trying to stop it. Okay, I can't answer that call. Family. Taking a break from writing my book. It's really draining me. I'm putting everything I got into this book. And it's taking me away from studies. It's taking me away from things. But as I put information into this book, I am coming across things. And well, let me slow down. As I'm writing a book, I'm also helping people at the same time. People call me up with their different problems and situations that they need assistance with, whether it be how to put together an affidavit, how to rebut presumptions, how to put in motions, et cetera, et cetera. And in helping people and going through my archives and looking up information for different people, I come across some things that hit me like, wow. So with that being said, as you can see on the screen, this is the Clearfield Doctrine. And let me read it, and then we can discuss it afterwards. The power that this document, not the document holds, but the information contained in the document. Let's be clear. So governments have descended to the level of mere private corporations. Governments have descended to the level of mere private corporations. That is the Clearfield Doctrine. Supreme Court annotated statute, Clearfield Trust Company versus United States, 318 U.S. 363-371, 1942. Whereas defined pursuant to Supreme Court annotated statute, Clearfield Trust Company versus United States, 318 U.S. 363-371, 1942. Quote, governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private commercial or private corporate commercial paper, Federal Reserve notes, and securities checks is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. What the Clearfield Doctrine is saying is that when private commercial paper is used by corporate government, then government loses its sovereignty status and becomes no different than a mere private corporation. As such, governments then become bound by the rules and laws that govern private corporations, which means that if they intend to compel an individual to some specific performance based upon its corporate statutes or corporation rules, then the government, like any private corporation, must be the holder in due course of a contract or other commercial agreement between it and the one upon whom demands for specific performances are made. And further, the government must be willing to enter the contract or commercial agreement into evidence before trying to get the court to enforce its demands, called statutes. This case is very important because it is a 1942 case that was decided after the United States Corporation Company filed its certificate of incorporation in the state of Florida, July 15, 1925. And it was decided after the corporate government agreed to use the currency of the private corporation, the Federal Reserve. The private currency, the Federal Reserve note, is still in use today. Here are the references. Articles of Incorporation, United States Corporation Company, which I'm going to click that link in a short minute. From the Great American Adventurer by Judge Dale, retired. That's another file. Corporations are not and can never be sovereign. They are not real. They are a fiction and only exist on paper. Therefore, all laws created by these government corporations are private corporate regulations called public law, statutes, codes, and ordinances to conceal their true nature. Do the judge and your lawyer know about this? You bet they do. Since these government bodies are not sovereign, they cannot promulgate or enforce criminal laws. They can only create and enforce civil laws, which are duty-bound to comply with law of contracts. The law of contracts required signed, written agreements in complete transparency. Did you ever agree to be arrested and tried under any of their corporate statutes? For that matter, did you agree to contract with them by agreeing to be sued for violating their corporate regulations? Enforcement of these corporate statutes by local, state, and federal law enforcement officers are unlawful actions being committed against the sovereign public, and these officers can be held personally liable for their actions. See Bond versus U.S. 529, U.S. 334 to 2000. Our government is just another corporation. So let's go to that first link. And it brings up the Articles of Incorporation, file 715-25. And I'm struggling to read it, but you can copy the link or copy the URL and pull this document up yourself. Okay. I'm actually going to go through each page, let you see it. So when you pull it up yourself, you'll see the same thing. Begin their business with $500. The United States Corporation. Now they incorporated in Florida. However, this is notarized in what county? State of New York, County of New York, July 7th. Louis H. Gunther, Samuel B. Howard, Arthur B. Britton. Be great to look up those names to see who they were, what they represent, et cetera, et cetera. So now let's go back to the original document at hand, because I need you to understand what we're saying here. Now, statutes, codes, and ordinances are rules and not decisions, rules and guidelines, things that organizations put together for other people to follow, like your manual, your job manual, your driving manual. These are steps and boundaries outlined for you to do or not to do. So that's merely what statutes, codes, and ordinances are. They are not law. They are called law. Now you can call it, or they can call it anything they want. Although they are statutes, codes, and ordinances, they can call it whatever they want. And most of the time they'll call it law. And you, if you don't understand exactly what it is and what's going on, if you don't get the gist of it, then you're going to believe it's law. It's not law. So the people, when applying or registering for voter registration, for even driver's licenses, these things are the contracts that tie you into the corporation. What am I talking about? When you register to vote, and you do vote, and even if you don't vote, but you're registered on the local level, local meaning your, not assembly, your, I'm drawing blanks here. It's got to be that aluminum in the food. Your council person, your mayor, your assemblyman, assemblywoman, these are your local legislatures. When you vote for these people, and these people create these statutes, ordinances, and codes, you are deemed to agree with it because you elected these individuals that created this nonsense. So that's how you're tied into it. People will say, well, I didn't agree to that. Did you register to vote? Yeah, I did. Well, then you agreed. How? Because you agreed to become a registered voter. And the purpose of a voter, or registering to become a voter, is to be a part of a group. The group now decides who they're going to pick as their leader. Once the group decides on who they're going to pick as their leader, they are led by that leader. That leader then decides who their team is going to be, who their cabinet is going to be. And now anything that these people delegate, you are bound to. So the registration of voter ties you in. The oftentimes they say the birth certificate ties you in too, but you know, a lot of these things is debatable, but clearly, voter registration, driver's license, these things definitely tie you into the fray. And there are small things that you can do to disassociate yourself from that. So now when these governments, alleged governments, because they're private corporations, incorporate. Now, keynote here, State of New York. I would love to punch in here, but it may take too long. When the state of New York was incorporated, because New York State is not incorporated. State of New York is incorporated. It's a duality. There is a county of kings and there's a Kings County. There's a county of Union and there's a Union County. There's a United States and there's a United States of America. There's a lot of duality that is being flirted in your face and you don't recognize it. And this is how they're getting over on you. I put a post up earlier today that you quit letting them run the train on you. That can tie into this, so I'll give you with that acronym I use, what it means when they train on them. When you are dealing with these private corporations, there are 4 things that happen. There's a presumption, meaning they presume you are one of their subjects, one of their citizens. You never want to be a citizen. Anyway, they presume you are one of their citizens. Next is an assumption. They assume that you are required to abide by their statutes, their codes, and their ordinances, and their rules and regulations. And then there's the tacit agreement. You agree by registering to vote, by applying for a driver's license in a particular state. Now, mind you, if you go to New York and apply for a driver's license, and then you move to New Jersey like I did, you have to give up your New York license and apply for the New Jersey license, meaning you can still drive in New York, but you will be representing New Jersey. Your paperwork is now changed to New Jersey. So now you are liable to the statutes, the codes, and the ordinances and the rules of those jurisdictions or that jurisdiction. But the Clearfield Doctrine is clear. And by the way, the P for presumption, the A for assumption, the T for tacit agreement, and the H, which I almost forgot, hearsay. When you go into their courtrooms, aka tribunals, the prosecutor will be stating the case, and the prosecutor will be doing most, if any, all of the talking. Everything that comes out of that prosecutor's mouth is hearsay, and you should immediately object. Objection, Your Honor, hearsay. Objection, Your Honor, hearsay. Objection, Your Honor. He should not be able to open his mouth. Why? Because he is testifying. And because you don't know any better, he is rolling you into a nice little big ball and about to roll you down the hill and hit a strike and put you in some cuffs in jail. You know, listen, let me say this again. And that particular defense is Trenzi versus Pagliari. Trenzi versus Pagliari. Real quickly, I'll punch this as I'm talking. And you need to read this one as well. Trenzi versus Pagliari. Should pop up here. But now, the presumption, the assumption, the tacit agreement, and the hearsay. Hearsay, hearsay, hearsay. Hearsay is secondhand information. The prosecutor was not there when this alleged crime happened, whether when the cop pulled you over or when you went through the red light or when someone claims that you got struck, et cetera, et cetera. So, and I'm having difficulty with my internet, so I apologize for that. But Trenzi versus Pagliari, I'll put that up in another video. Now, because they were not first-hand witnesses to the incident or to the action, they cannot speak. They must present evidence. They must present something from someone that was there. Got me? So it's hearsay. All of it is hearsay, hearsay. There's a lot of times people never see a witness or the accused. It's always the prosecutor in court making the case, the district attorney making the case, the lawyers making the case. But where is their evidence? Their evidence is what they're saying, and what they're saying is getting on record because it's not being overruled or objected by anyone on your end. And if you have a lawyer or an attorney representing you, believe me, they're sitting there because the longer it goes, the more they get. Whether they win, lose, or draw, they're going to get paid. But they're railroading you. They're railroading you. Presumption, assumption, tacit agreement, hearsay. Strike all that down and they have nothing. So back to the Clearfield Doctrine, ladies and gentlemen, and you can pull this up for yourself, read it, understand what's going on. And I explained to you already the duality. There is a New York state and a state of New York. The state of, anything of, county of, state of, those are corporations. When it says New Jersey state, that's the actual de jure, real, living area. When it says state of New Jersey, that is the corporation, okay? So if you are being brought up on charges and your case states state of New Jersey versus such and so, immediately you want to face your accuser because the state of New York is bringing suit. Okay, you need the state of New York in the courtroom and not a witness, not an agent or representative, because this is how they're getting over people. You got to pay attention to this. You got to really, really pay attention to this. The state of, the state of, the state of versus you. And oftentimes they'll put your all caps name. I'm going to say 99% of the time they're going to put your all caps name because corporations can only deal with corporations. They cannot deal with the live living man. So you're not supposed to be in that court. And if you're in a court, you have to speak to a mouthpiece. That is, if you're a minor. If you are of the age of majority, then you can speak on your own. And there are things that you need to do to put that status on the record or to make that claim. Also, I'm not going to bring it up here, but the affidavit of corporate denial is a very strong piece of information because these people are presuming and assuming that you are something that you are not. And if you don't rebut it or dismiss it, you are that. All right, that's about enough. This went long enough. You got to pay attention to these documents that I bring forward to you. I'd love to do a package of step-by-step from accused to arrest to trial to dismissal. You know, I have documentation from motions, and well, we'll do another video. I think I've said enough. This is the Clearfield Doctrine. This is what it will be labeled as, the Clearfield Doctrine. And please do not let them run a train on you. In New Jersey, we have a train perfectly labeled the PATH train, P-A-T-H. And consequently, that's a presumption, that's an assumption, that's tacit agreement, and it's hearsay. Do not let them run a train on you. This is Bud Brownsville, in case you haven't known. And this has been a Marshall Enterprises presentation. And this is the end. I thank you for listening. Please click like, please share. And please, by all means, comment, good or bad. Be well and enjoy your Thursday.